all the time in Carroll County. I'm just saying. It's a very, very unlucky place to live. They dropped the charges because it was accidental. You don't accidentally run over somebody and back up and try to do it again. Let's start from the beginning as investigative reporters, right? So you would ask the questions who, what, where, when, and why. Should be easy, right? Of course it is. Yes, I know, you're innocent until proven guilty, but what good does that do you if you are not alive? Hello, good morning. Can everybody see and hear me? Ugh, yeah, I have been sick as a dog the last couple of days, but I promised you that I would, let me see here. Let me promise, bleh, bleh, bleh. I promised I would do this, and so I have had the worst time. It's setting up. I've had like people are probably confused. They don't know what link. I've had 3 different links up this morning. It's operator error uh, because my brains they're not all together. But anyway, how are y'all doing? I hope everybody is warm and safe. Uh, it's been terrible. It's like 21 degrees here. And we don't do that in the South. In Alabama, we don't do this kind of weather. And so, yeah, it's been miserable for all of us. I think the first time I have called out on my job, I've been there for almost 2 years, and I called out yesterday because I was just, ugh, can't. I just couldn't. I couldn't sit upright. And so I will be upright, and I hate that I started so late. I wanted to actually start about 9 because I know I haven't talked about anything in the last document drop that came out. I haven't talked about, the affidavit, and I've got a copy of that, and I wanted to go over it, and maybe we will later because I just wanted to look at some of the things, working in corrections. I wanted to weigh in on some things that I think are completely non-standard, and some things that are, which I've said a lot of this before. I honestly, when we started this whole thing, and it started in the springtime, I at first, and I go back on my old videos that I did like 7-8 months ago, and uh, I kind of cringe at some things, which everything that I said is 100% true, but I cringe because even at the level of understanding that I have, Richard Allen is not. I've changed my opinion a lot on the way I think Richard Allen is being treated, and that's coming from me. Working in corrections, knowing how things usually are. Oh, geez, there are some things that are just reprehensible, but then some things I wanted to explain might not, excuse me, be that abnormal. Everybody's seeing and hearing me okay. I'm trying to talk loud, but I don't know if we'll get into any of that before the court hearing because I really, really I hope this link works like it's supposed to. And it says it starts 2 minutes before the time. So I'm on Central Time and they're on Eastern. So we've got about 18 minutes or so before it starts. Um, and Okay, good. Thank you, Deb. Uh, yeah, I know everybody's watching from all kind of channels, and I'm late to the party, so it is what it is. But we'll still watch it, and I am so glad that y'all are here. Um, give Say hi if you're watching. Type a hi in there, would you? Um, anyway, yeah. So this court hearing, I'm nervous. I'm not gonna lie, I'm nervous. I don't know how this works. I think my understanding, okay, is that they're going to listen to the arguments, but I don't expect a ruling today. Um, I don't know. Are y'all nervous about this? Because I really, really am. Um, I really hope for due process. Hello, John Smith. Hi there. And then see, I can see that there are people watching, but you're just not saying anything. So, uh, just a hi is fine. Um, if for any reason it's just my weird looking icon up here, it's probably because I had to go. Yeah, yeah. Um, Good morning, Caddy Crime Ghoul. Good to see you. Um, yeah, Summer. Hello. Oh, am I the first one that popped up? Well, good, good. Uh, like I said, I know people have, creators have started before me, and so a lot of people are already in their broadcasts, and that is all on me because of. I'm not even going to say it's because I'm so sick. I think it's just because I'm an idiot. And I could not set it. The brains just didn't set it up right today. But anyway, we will watch it and then we'll talk about it. I do have something I want to tell you. I am talking, I think if you didn't see my last thing, I was talking about Epstein on one of the last episodes or lives I did. But I'm in contact with some lawyers from uh, Indianapolis, and I've been emailing them, and I've got to email them back and set up a time to talk because I wanted another opinion on this channel, and these are people that you probably haven't heard of, but they do have a channel, and I was watching some of their videos, and they seem like very uh level-headed. Everything that they said was just extremely right balanced. Okay. And so I have a lot of questions regarding this case, just as far as due process. And so hopefully within a week or so, I can have them on, their schedule, my schedule, whatever. But I'm super excited to introduce them to you, and let's talk about it. Uh, okay. All right. So, let me ask you this. Did everybody watch the Somebody? And let me just tell you this. If something happens, like the weather should be fine. Here it's cold, but I think my connection's okay. If anybody loses, if for some reason something drops, go to Crime Night. Joe Lewis is doing this too. Uh, he's a sweet guy, always very supportive of me as I am of him. Okay. Um, and of course, there's a lot of places doing this. But did you read the affidavits? Okay. The last document drop was I was at work, and I thought, well, I'm gonna do it tomorrow, the next day. I thought I'm gonna just cover this, and everybody was okay. Everybody was, and I thought I'm not going to put y'all through that same thing. The only thing that I have to say any different is about from a perspective of working in corrections. Okay. and that I can weigh in on. And good morning, Kip Kitty. How are you? I hope everybody over in CJ Land is good. I haven't even looked. I haven't even been in Discord today. I do have a Discord. I am almost never on it. Well, I said, let me take that back. If you message me on my Discord, I will respond to you quicker than any other way. However, I haven't been posting in there lately because there's just so much going on behind the scenes. I do talk to people frequently on my Discord in private messages a lot. So if you want to, and of course, if you got something to say, you can email me as well. That's also on my channel. I think it's on the about page or whatever. All right, what time is it? I don't want to miss four. Okay, it's 9:46 my time, which is 10:46, I think, in most of Indiana. It's very confusing to me because some people are in Central time zone and some are in Eastern, and that messes with my head. I'm glad Alabama is all in one time zone. That is the most that we can handle here. Okay, it's bad enough. I remember when this is how old I am. I remember when I was a kid and we only had one uh, area code for the whole state. And now we've got like three, maybe four. I don't know. It's crazy. Crazy. So ours changed. And that messed me up for a little bit, but I'm used to it now. It's been a long time. I am glad. Thank you, Kip Kitty. I am at least sitting upwards today. I laid down all day yesterday. It was terrible. I'm still a little funky looking, but yeah, whatever. Whatever. It's not about me. It's about watching this. And what do y'all think? Let's take a quick poll. I have an app for that, but I don't know what I'm doing. Um, yes. Let's take a quick poll. What do you think is going to happen? Do you think the Supreme Court, is going to rule in favor of Richard Allen or in favor of Judge Gull? Because yeah, part of my anxiety right now is the feeling in my stomach is just I'm sick. I've got a stomach virus. And the rest of it is I'm I'm nervous. I'm nervous. Cuz look, y'all, you've heard me say this for over a year now. I don't know if Richard Allen is guilty. It doesn't seem to me like they have nearly enough evidence, but that is not even, they may have it. We just haven't heard it. Whatever. At this point, it ain't looking good. But what I am, what I'm really focused on, or is just due process, okay? Because I've said it over and over. If the Supreme Court rules badly, in my opinion, it is badly, because I feel like what Judge Gull has done is just completely been lawless. Just did her own thing. And it's important for due process. It's important for due process for Indiana, but also for Alabama. If they set a precedent like this, okay, it affects everybody. And that is a scary thing to me. This man deserves a fair trial. If he's guilty, I've said it. Put him under the dang jail. Like, let's just start digging if he's guilty. All right? But if he's not, or even if, let's just let him have a fair trial. Okay? That's all we're asking for. That's all I'm asking for myself. If I ever get into some kind of crazy position, I don't anticipate it, but I don't know. You never know what you're going to do in a situation. Even if it's self-defense. So let's really make sure that due process stands. That is what our Constitution is about. And I am not neither pro or con. I have to say I lean more towards Alan is innocent, just because of what the facts that we've seen are horrendous. But I can't say that with 100% certainty. I would love to be a juror, you know, because I do think I keep an open mind. I want to hear it all. I want to hear it all, and I want to know the truth. Um, okay. Oh, okay, John Smith. Let me tell you. Um, oh, okay. Somebody gifted memberships. Okay. This case is about Richard Allen, who is being accused of the unaliving of Liberty German and Abigail Williams, two teenagers who were abducted, I guess, from there's a lot of there's a lot of controversy in this case from the Monon High Bridge in Delphi, Indiana. Now, the problem with this case is that the judge, he was given public defenders, and let me just give you a brief history. From about 5, 6 months into them getting the case, he started deteriorating in the prison. He is not held in a county jail where most uh, types, I work in a county jail. Most types who are not convicted yet, haven't come to trial, are housed in county, but they housed him in the Department of Corrections. Let me make sure at my time. And so there was a lot of controversy. He started like really not looking good. Okay. And then his defense attorneys asked him to be moved, and they shut that down. And then in September, his defense attorneys came out with a Franks motion, which is a whole kind of a rare thing. But in this Franks motion, they wanted the evidence thrown out because they said it was not like it wasn't true. The way they obtained it was through lies, and the judge that signed off on it, like within a day or so, recused himself. So they got Judge Francis Gull, who, after the Franks motion came out, as far as the YouTube creator and Delphi community, like they all lost their minds. Like everybody lost their minds. There's a lot to this case. Well, um, what happened is the judge just decided basically she didn't want those two attorneys, Rousey and Baldwin were his original attorneys, and she said she didn't want them on the case. She cited all of these reasons that they should have had a hearing for, but she just threw them off despite Richard Allen's begging her, like, I want these attorneys, and they even offered to do it pro bono and at their own cost, and she still would not reinstate them. So now they have taken the case up to the Supreme Court saying, hey, this guy deserves the attorneys that he wants who are willing to represent him. And they were thrown off the case without even a hearing to say why. She just said she found them, what was the words, y'all? I'm sorry, sick. But I can't think. But anyway, she said they were not good attorneys. Basically, he deserved better, and I think it's because they brought up a lot of stuff that was just bombshells in their early documents. So that is what we're deciding on today. We're listening to the two sides say. Basically, we are trying to decide whether Richard Allen should have the uh, defense attorneys of his choice according to the Constitution, or if you just get thrown in there with somebody that you didn't choose. Now, though, his new attorneys are agreeing with the old attorneys, so that's a whole that happened last week. I'm like, whoa, geez, are we getting set up here or what? Let me see. Let me go back to, okay, we got just a couple of minutes. Let me go back to your, somebody was gifted memberships. Who did that? Thank you. Thank you. Kip Kitty, thank you. That's so sweet. Ah, I appreciate that. Um, all right. So no, there's no reason if you don't know this case, hey, I'm glad to tell you, because like I said, this when you set a precedent, okay, checking on the time again. When you set a precedent, even though it's in a different state, even though it's in Indiana, all the states, they look at cases like if there is a crime in Alabama and they're looking for a precedent for the attorneys to argue over whether this you can do this or this is whatever. You know how the law goes. Um, they don't look for just cases in your state. They look over the whole United States and they say, okay, up in Washington state, this is what happened in this case. They had a similar situation and this is how the judge ruled. And look, most of the time the judge will rule the same as the other case. So what happens here is if a judge in Indiana can just say, you know what, I'm having a problem with these attorneys. I don't like them. I don't like the motions they're filing. I think they're inept. Whatever. They have really made me mad for getting all this information out there, whatever her cause is. And you know what? I'm just going to kick them off the case. Well, guess what? In Alabama, if I have attorneys that I want and the judge doesn't like them, if she sets the precedent and the Supreme Court says, oh, it's okay, a judge can just kick anybody she wants off, there's a problem for me. Because then what? You get attorneys that may be substandard or maybe not. But you know what I'm saying? That it's ridiculous. No one should be able to tell you. Now I know in a public defense thing, when they're assigned to, you're kind of, if you don't have the money, that's that. But in a case where you want these attorneys, know whether they're good or bad, even if you want a horrible attorney, but you're determined to have them, that is your right. That is your constitutional right. And this is the problem here. Okay, let's go. And we will talk about some other stuff when this, I just don't want to miss this, okay? Let's make sure I know what I'm doing. I hope this works, y'all. Okay, it says it's going to start. Y'all can all see that. All right, all I can do is wait for this video player. And if the picture's bad or something, I might have to adjust. But this comes from, let me just tell you this. If you get lost somewhere, this is at, just look up the website, Indiana Supreme Court, and it is on one of their tabs, okay? All right. Anyway, I just want to be sure. So wait. Okay, because now it says it's 9:58, 2 minutes before. We're waiting. I think I'm gonna pull it up on my phone too, just to make sure, like, we're not missing anything. And it's indeed playing like we think. It wouldn't be surprised if Indiana makes us wait. Let's see. I have to get my glasses out here. I can't see squat, y'all. All right. Good to see you all in chat. Let's see. It says watch oral arguments. What? Okay, I'm on Chrome here. What? All right. Let me see. Oh, it says my browser's outdated, but that's on my phone because it's all right. Let me see. Oh, Lord. Here, because that's changed a little bit. Website. I know y'all aren't seeing any difference right now, but I'm pulling up another one so I can switch real quick. If There we go. Ah, all right. Let's. Yes. All right. Hold on. There we go.
We'll be arguing the case. At council table, we also have Kara Winnicky. Good morning, Ms. Winnicky, and Bernice Corley. Good morning and welcome.
Can y'all hear
Bernice
that?
Corley. Representing the state of Indiana at council table, we have Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and council. Council, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes, so you ready to proceed?
Can y'all hear that? Because I can't.
All right, Mr. Lehman.
Okay.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes, and when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where, in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial was...
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it for they had it for 2 months and didn't file it. Your client signed it in August under the...
Yeah. Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But, Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with a senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve...
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Waive what concern? Waive any? For example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride or die with these lawyers. I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it. I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, and you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent.
lawyers,
I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge. I'm going to go out there and I'm going to say these things, and Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because
Honor.
you're saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think I don't think those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
My
Amendment
concern is getting
requires.
this case back on track.
Yes.
All right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge that there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's a structural error, and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
There's a lot of events in this case that led up to that hearing, correct, with regard to sending information on a case to another criminal defendant, with regard to Well, there's a lot. I don't need to go through it. It's in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer is not being a lawyer at that point. They're not
Filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest and says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, and other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted. Can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those. But no, I'm going to change that, Justice. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial and that fully and fairly advise him that that's a repercussion. But if when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
well, Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge, or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did?
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason. There's an intimate relationship going on. And she pulls them in, goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that, in that case, it would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery has the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask, with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say for example the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel, Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice-only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October, and when the judge said it in October of 2024, one of the lawyers, I believe, even represented he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, through the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance of counsel.
But I'm really struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing, we don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat, as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case, saying a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having all the everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if she If the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court, one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for a matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So
Well,
your
tell us why you
solution,
think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective.
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in 2 ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be...
but it has to be done, there's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on, I think you're incompetent, and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed. So, which means...
Well, we won't know what would have happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the right of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. Here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of making?
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys, and so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with lots of different people playing, I mean, in the Wheat case.
Wheat
I don't see
himself,
wheat as tucked as neatly as you find wheat. So
Wheat
go
him-
outside wheat and give me something else.
well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on
where can you point to me saying, with regard to saying somebody is incompetent or negligent? That's like, we have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, Wheat went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal, what possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, you know, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't
this.
that protect everyone's interest in finality in the
Yes.
long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interests, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly, on this record, has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen, counsel today, seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will believe.
Do you agree that with, under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is, in fact, the person who was making that choice, that he was, in fact, competent to make it. There's been many consistent allegations about his mental state throughout the case. And then, of course, that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The
significant,
default rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte, on her own motion, disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular things cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's a writ. There's no order. There's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so even now.
Well, tell us more
in the
about that.
trial court.
What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see my time's up.
By the bell, huh?
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? We don't know. All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gall, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen, and because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, We trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing, here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana, for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as WEAK's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. You pull the gentleman in, and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward. Yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being relating to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise to ineffective assistance of counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration, and we ask you to grant the relief requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible. All right.
Wow. Wow. Okay. Let me take these out now. I can hear. Yeah, he had a shaky start. You're right. I don't know if that was maybe nerves. I don't know. Ugh, it's freezing in here. So, what did y'all think? Like, a couple of things just really stood out to me. And I feel like I understood about 90% of it. There are some things in the law that I obviously don't. I was not sure what that meant, but for overall, I think I understand. Here's the thing. They kept saying possibility. The possibility. This is the first thing that struck me. There's a lot of possible things. We could get, invaded by China today. That's possible in the realm of everything that could happen in, in life. But it's not probable, okay? Not today. Uh, are we going to live? Are we going to let our justice system be ruled by possibilities? Because, like, anything's possible, right? Uh, that bothered me. Okay, we need probable. Probable. That's how we, live our lives. We think probably the sun's going to come up. We think probably, we're going to have a relatively normal day where we have, we go to work and we come home, we just face the normal struggles. That's probability. Possibility, of course, we all have those days where, like, everything just, goes off the charts. But you can't rule a case on possibilities. And then that was the second, getting convicted on a possibility. You're right. I'm going to highlight that, John. Yeah, getting convicted on a possibility. That's it. And then the other thing that the state brought was that just tore me up was ambiguous. It's ambiguous. This is ambiguous. That's ambiguous. What she said, blah, blah, blah. Okay, look, if it's ambiguous, then there's two possibilities, right? It's like one thing clashes with the other thing. So if it's ambiguous, I mean, it's not like a clear cut, somebody violated the rules, or it's not a clear, well, I think it is. I think Judge Gull clearly did, but that's my opinion. But then you have these, well, this is ambiguous. Then shut up. Then why are we talking about it? If it's not clear cut, then why are we even talking about this? Why are they, if there's all this ambiguity going on, then why are we going against the Sixth Amendment and taking away Richard Allen's right to his choice of, counsel? This makes no sense to me. I mean, who's going to argue ambiguity? Well, that's like saying, well, we don't know, but sounds like maybe. I don't know. Possibility that it's not correct. Possibility that there's two things. Does this seem as ridiculous to y'all as it does to me? Again, I'm not saying Richard Allen is guilty or innocent. I'm saying this is due process. And it's you, and it's me, and it's our family, our kids, our parents, our friends. This is all what is on the line if they allow someone to just come in and say, well, I have an opinion and it's ambiguous, but I think I'm just going to remove these people. That completely, you might as well just shred the Constitution. Do y'all see the problem? This is why I'm so fired up. This is why I'm so angry about this whole thing. Like, and somebody brought up Ted Bundy. John did. He's like, well, how does Ted Bundy get to be clearly insane? How does he get to be his own attorney? Because he has that right. But yet we will let Richard Allen have the right to his attorneys of choice, but we'll let Ted Bundy get up and make a fool of himself in the courtroom, marry his girlfriend there. It was a circus. All right? And I would argue the same for Ted Bundy of the right to due process. Should he have been removed? Yes. Should he have had effective counsel? Yes. And come to that decision, he was clearly guilty, okay? No doubt about his guilt. And yes, did he, was he prosecuted to the full extent of the law? Yes, he was. And I mean, whether you are pro or anti, death penalty, whatever, that's not the issue. The issue is that everybody deserves a fair trial. First of all, look at the Indiana residents who are footing the bill for this. Because, Will they, if let's just say Richard Allen goes to trial with the new attorneys and he is found guilty, what do you think's going to happen? They're going to peel it right off. And yeah, you're going to do this all again. So why even go through the trouble? Let him have his attorneys. Okay? Let them present the case. Let the jury decide. That's what this country is. That's what we were founded for. Due process, the right to do, the right to the attorney. Let's have an actual court of peers. Okay? That's my opinion. Yeah, I know. I'm getting all I'm getting all upset about it. Uh and you know what, Megan, I am Daryl Brooks' trial. I have not watched that. Yes. Okay, John Smith says in Britain, you cannot be convicted on a probability in a criminal court. Only for a civil action can you be found guilty on the balance of probabilities. Yeah, and I think that isn't that the same here? It's true here too as well, because in the O.J. Simpson case, remember, he was found not guilty in a criminal court, but he was found guilty in a civil court. Completely different. That's about money. That's not about, you know, being incarcerated or whatever. Megan, due process and presumption of innocence matters, or it should. Yes. Yeah. Uh, I'm gonna have to watch that Daryl Brooks trial. I really am. Gosh, I don't know how I missed that. But yeah, again, innocent until proven guilty. And let me just say this, uh, just to end up, because everybody's already covered the affidavit. I've got it pulled up, but we've already been here for like an hour and a half, and let me just say this: there are a couple of points on that affidavit. And let me just tell you, okay, I found it mind blowing that Scremin and Labrato agreed with the old defense. Like, I was like, holy crap, really? I mean, come on. If you're honest, we all thought Judge Gull moved Rosie and Baldwin, and because she didn't like them, she didn't like the information that was coming out. There was a lot of, made the state look bad. I'll just tell you, it made it look real bad. So, she throws it out. She dismisses them. She appoints new attorneys. Some of them are friends on Facebook. We all thought we knew where this was headed. And I don't know. But I was quite impressed with them standing up for Richard Allen. I know that's their job. But let me just say a few things. There were, and clear up a few things that were in that affidavit. First of all, Richard Allen said that he was getting medication and it was different. The number of pills, the colors, and all this stuff. Okay, I've got two sides to this, okay? On the what the heck side, if he has not seen a doctor or a psychiatrist since he's been at Wabash, and he doesn't know what they're for, why is he taking this medicine? That is a problem, okay? You should absolutely not be taking medicine you don't even know what it's for. That's ridiculous. I don't know what his mental state is. But now, on the other side of the fence, being medical in an institution, there are a couple of things. You have a thing called stock drugs, and then you have pharmacy drugs. Now, for us, and I'm just saying for us, it all comes from the same pharmacy, but there are some drugs that we order in larger quantities, things that when people come in, they may need to start, such as antibiotics, that they may need to start, or heart pills, blood pressure pills. There are certain standards in the industry that a lot of people take, and the doctor will say, let's start him on, let's just say somebody's having a blood pressure problem. The doctor may say, let's put him on lisinopril 10 milligrams, once a day. Well, if you're having problems, you don't need to wait a couple of days till it comes in with their name on it from the pharmacy. You take it from the stock that we have and you start it right away to, get medical treatment for that inmate. So now when it comes from the pharmacy in their stock from the bigger place, they may have changed manufacturers or where they get that medicine from. Especially if it's a generic drug, which it usually is, then different manufacturers, it can look totally different. Okay, the pills can be totally different, and the number. Let's say you've got 10 milligrams of lisinopril in stock, but the doctor orders 20. Well, then they're going to get 2 pills. But then when they get it with their name on it from the pharmacy, it may only be 1 pill. Okay, so there is some variation on what we do. And if you run out, let's just say there's a pharmacy thing that the prepackaged medicine, they skipped over somebody, they didn't send it. So one day you get a pink pill and you're like, okay, this is what they're normally getting. And then the next day you get, instead of 1 pink, you get 2 white because we had to take it from stock because we don't know. Why didn't the pharmacy send you medicine? I don't know. But we got to fix it. So there is some reason for that. However, you should not be taking medicine if you say, I don't take medicine, and then all of a sudden you're getting medicine and nobody told you. You didn't see a doctor, a nurse, a psychologist, or a psychiatrist, whatever, to say, hey, we're putting you on this. That is a problem. The other thing I would say is, again, they're not wearing the odorless patches. They've got odorless tattoos. God, that's scary. Again, that to me, that is intimidation. Going through all of the things that they went through on that affidavit talking about they had no privacy. Again, I work at a county jail. We have a room where our inmates can meet with their attorneys. There is glass between them. We can see in there, but usually we really use the cameras for that. For if there's a time that you're holding somebody there temporarily for a very short period of time, not to sleep or anything like that. When I say short period, I mean a couple of hours maybe. But the reason we have a guard that stands outside the room, you can't hear, not listening to the conversation, but they can meet with their attorneys between glass. And the reason that's between glass is because it's for the protection of the attorney, really. Some inmates, when they get bad news from their attorneys, they just, they lose it and they want to hit something. Well, there needs to be some glass in between there. But otherwise, you have an officer that's standing outside the room, not with his ear to the door, just standing there, making sure that everything is going okay and that the attorney is not saying, get this person away from me, we're done, whatever. They don't seem to have that liberty. Being chained up, all this kind of stuff, it's overkill, okay? And to me, that would definitely, if you are intimidated, even if it's just in your head, okay, let's just play devil's advocate and say that it's all in Richard Allen's head, all right, that he's being mistreated. I mean, you have some physical examples, then why chain somebody? That is only going to feed into that. You see what I'm saying? It doesn't make sense. It doesn't make sense. And the more I look at it compared, now, yes, do I know that prisons are not really equipped for this? Yeah, because you're already convicted when you are sent to DOC in most cases, not always. That in itself is not 100%. Now, for being in the situation he's been in for this long in PC, oh God, I can't imagine. Most people would, kind of crack up after that. So I understand it's a terrible thing for him to have been this long, and now they're saying they want him to wait until next October, almost another year, for the trial to start. No, no, that is not okay with me. I find this to be a big problem. So there's, kind of, and like I said, Megan, you might be right. I still smell a rat with these new guys. Hey, I'm not going to put it past the realm of possibility that this wasn't, a move by them to make us all think, oh, they're the good guys. Okay, they're still good. They might not be Rosie and Baldwin, but they're still on his side. That is a distinct possibility. Okay, I hope. Okay, that's fine, Sandra. Yeah, I'm gonna hush here in just a minute. Anyway, I'm just about done. Uh, thanks for sticking around. Enjoy your dinner. What you making? All right. Yeah, I think that the best case scenario is that the Supreme Court rules that Rosie and Baldwin can be reinstated. That would be the best for Richard Allen, for his mental health, and for a speedy trial. That's my opinion. What do y'all think? Let's take a poll. You think? Who do you think? I was so convinced. I wanted to puke at the beginning of that. Okay, I wanted to just throw up because it seemed so hard on the defense, but then they were like really, really hard on the prosecution. So I was like, well, good. Maybe they're looking at this fairly, because what I heard from the Supreme Court is that uh, there should not, to me, it seemed like they were leaning as this is not, you haven't proved a constitutional, reason, like you're violating his Sixth Amendment rights, that this is not a reason. And I think one of the judges, the female judge, she was like, you haven't given a reason that he should not have his attorneys. That was my takeaway, and I was relieved because, again, we want a fair trial. The end of the day, all we want is a fair trial, and I hope we get one. Okay, I don't want to be talking about this case. I don't want to be talking about this case in 2, 3, 5 years, 10 years on appeals. Like, look, again, he's not the only perpetrator, and everybody's looking this way. So, I hope. Yeah, they did seem to lean toward him. I'm skeptical too. We've had hope before. Like, look, when Rosie and Baldwin said that they were going to do this pro bono, I was like, okay, well, what can she do now? Well, she did it, didn't she? All right. So we're just going to wait and see. Thank y'all so much for hanging out with me here. I've missed being live with y'all. I really have. I may go live tomorrow if I feel okay. Look, let me just ask you. I've got this case I would love to talk about. Like, look, it's completely closed. While we're waiting, unless the Supreme Court comes out with a decision today or tomorrow, I mean, we're just kind of in, la la land here. But I have a case that I would love to share with you. It is the Alabama snake handlers. Now, this happened years ago. It is the most ridiculous, like mind-blowing. And it ain't just the circumstances of what actually happened in the perpetration? Is that a word? Am I just making stuff up here now? I don't know. It's not only just the crime. It is what happened during the trial. It was, oh my gosh. It sounds like maybe the Daryl Brooks thing, but that is nuts. But yeah, I've got a lot of documents on. We've had more than one snake handling case, but and as just FYI, there are some people, and actually not that far away from me, maybe an hour and a half, 2 hours from where I'm from, that still do have that practice. They are getting smaller in number. I'm just going to go ahead and say it, thank God. But yeah, so if you want to see that, I might do that if I can get my stuff together and be able to stay vertical again tomorrow night. I may do that. Anyway, thank you so much for hanging out with me. Let me know what you think. Where are we going? Fingers crossed, y'all. Uh, Stay safe out there. It's cold. Drive safe. Whatever you do, just stay still. Just stay silky. Bye bye.